And lawyers, guns, and money.
This was an emergency Instagram live. So for those that have not been following what's going on in Nebraska, 8 Nebraska players sued the Big Ten Conference. There's a lot of misinformation about there as to whether Nebraska University is the one that sued the Big Ten. So we're here to kind of set the record straight. We're going to keep this pretty tight, maybe 10 minutes. Dan and I can be a little bit verbose, but we'll keep it pretty tight. So the long and short, 8 players are suing the actual Big Ten university. About 2 weeks ago, head coach Scott Frost basically laid out that the university was committing to playing no matter what, even if they weren't going to play in the Big Ten. Since then, it looks like Nebraska's taken a step back, and they said they're going to abide by the Big Ten or the Big Ten's decision. That has not stopped these 8 players from suing the university. They have 3 counts in their complaint that they filed. Number 1 is tortious interference with business expectations. We'll get into it. Number 2 is breach of contract. And number 3, lastly, is a declaratory judgment to declare that their, let's say the Big Ten's finding of, that the season should be canceled was invalid. So those are the 3 causes. And now the reason that within basically a day of filing this complaint that there's been a court hearing, there was a Zoom hearing at 3, I think it was at Lancaster County, is because they are asking for emergency relief, which is called an injunction. So in New York, we have something called an order to show cause. I'm sure there's a Nebraska equivalent, but they're filing this thing super quick to get in front of a judge because in theory, this is emergency. They want the season back on because they've been practicing and they want the season to move ahead pretty quick. So that leaves us to today. We had a hearing at 3 o'clock. Dan, I got a lovely text from Dan about an hour ago that we should go live. Dan feels very passionate about this. Dan has been undefeated in his predictions on our show.
This week.
No, like forever. It's fine. For all time. So the floor is yours. What are your thoughts? What are your thoughts overall on the Nebraska lawsuit?
Well, it's a lot of pressure here to deliver now, but I've done a little bit of research. My initial gut reaction was that there were going to be some standing obstacles. While this is not federal court, every state court system and every state substantive law has certain rules of standing that would entitle, before anyone can sue over a particular cause of action, you have to be aggrieved and you have to have a legally cognizable interest. And here, I think there's a real standing problem, at least with respect to the breach of contract count, because there is no direct contractual relationship between the students or the student athletes and the Big Ten Conference. And the plaintiffs here and the lawyers are trying to use language in the bylaws and the Big Ten governing documents to sort of, create a contractual relationship between the players and the Big Ten. And courts that have heard issues like that in the past, especially in the Ninth Circuit, have rejected that. But I think the biggest problem or the biggest hurdle that the plaintiffs are going to have to overcome is that in their tortious interference count, it is predicated on name, image, and likeness rights under a Nebraska statute that can be implemented at any time between now and 2023, but the university has not yet opted in to the NIL statute. And in the absence of that opt-in, the case, or at least that claim, is unripe as a matter of law. And then overlaying this entire thing is the notion that courts are generally loath to interfere with the internal affairs of a private association such as the Big Ten.
Well, I'm going to virtually, if we were doing the podcast, I would probably just interrupt you, but we're Instagram Live, so I'll let you go. So Dan, now here I think is the interesting, and watch this. Want to see my Westchester Bar Association tech savviness? Okay, so what we have here, we have the complaint that I pulled up. Dan, I can see your face. You're super impressed, and everybody in La La Land is also impressed. Okay, so what we did look at, if we look at the complaint, and our friend of the show, Darren Heitner, did share this with us. This is actually a copy of the complaint. We're happy to send this out as well. So in the Big Ten, as fancy as it sounds, I'll come back for now. I'll do the big reveal in a minute. In the Big Ten, as fancy as it sounds, there were actually 14 schools. So according to the Big Ten bylaws, at least according to this complaint, upon information and belief, in order to cancel the season, it has to be done by a formal vote, and 60% of the schools have to assent to the cancellation of the season. So just basic math, that means that 9 schools out of 14 have to say, A, that there was a vote, and B, that they voted to cancel the season. The problem is, which doesn't really make sense, just objectively, you don't have to be a lawyer to understand it. There are people that are in the room that are saying that a vote didn't occur. And then there is the Big Ten commissioner, that's Kevin Warren, who's saying a vote occurred and we got 60%. There was a vote. And then so anyway, so it's weird, right? You can have the Big Ten commissioner saying there was no vote, but then people in the room saying there weren't votes. So here's the big reveal, the tech stuff. So this is John Gabel, is the president of Minnesota, per their complaint, and we've seen this on Twitter. We've seen John Gabel make this statement. Gabel has been publicly quoted stating that the council did not vote. Okay, same thing from the president of Michigan State University, has been stated as that they did not take a formal vote. And then one more, this is the athletic director at Penn State, has been publicly quoted as saying it was unclear as to whether there was a vote. So now, Dan, you did mention, and I want to give you credit for this on Twitter, and I think you were quoted in an article as saying it as well, but more often than not, courts are not inclined to involve themselves in the affairs of a private association unless, Dan, there is egregious conduct. What are your thoughts here? Do you see anything here that could potentially apply?
Well, there are always exceptions to the rule, and the general judicial reluctance to interfere with private associations' inner workings has a number of exceptions, such as failure to follow their own rules, right? So one of the linchpins of the complaint was the allegation that the Big Ten did not adhere to its own guidelines. So there was a reason why that allegation was made, to sort of fit within one of the judicially recognized exceptions to the non-interference doctrine. The other potential exception is that when you move away or you move closer towards substantial economic interests being involved, courts are much more likely to weigh in when there are such economic interests at stake, as opposed to just interfering or entering into a dispute over discipline, expulsion, suspension. But the problem is, while the players have alleged their name, image, and likeness lost opportunities, which would seem to lean towards there being substantial economic rights and interest, they've also disclaimed the notion that they've suffered any economic damages in excess of $75,000. They basically said our damages are under $75,000, simply as a gamesmanship or forum shopping, because once they plead over $75,000, it puts them at greater risk of having
let me say it, Dan.
removed to federal court.
Oh, I was going to say diversity jurisdiction. That would get you. You need 75,000, right? You need diversity. Oh, you need diversity of citizenship, and then separately, if there's is it federal question on my civil procedure?
You can either have a federal statute, a federal constitution.
My Civ Pro stuff is still pretty solid.
Dan, you're doing really well. I can see you got a big future ahead of you in the law.
Oh, wait, hold on. We have a question from the crowd, and I did want to touch on this with you. So Jack Wilson has asked, can you touch upon the Nebraska parents' FOIA request? Now, Dan and I did touch upon this. I believe it was episode 56, the Lawrence Taylor episode of Conduct Detrimental. Right, Dan? Not Gary Reasons, Lawrence Taylor.
That's right, Lawrence Taylor.
So just very quickly, and I think Jack's hinting at an interesting point here. Apparently at the hearing today, and I didn't have a chance to watch it, but Nebraska is saying that they are not bound by FOIA requests, which you have also pointed out in the podcast that as a private association, you're not bound by FOIA.
Well, hold on. Penn is not bound by FOIA. I think if this was a Nebraska state public records request, if the university is a public school, then they might have.
But it's not. This is to the Big Ten.
The Big Ten isn't subjected to any Nebraska Freedom of Information Act laws or any public records requests. They're an out-of-state entity. That FOIA request would have to be made within the Big Ten, within Illinois, and even then, as a private association. I don't think they have any obligation to provide those kinds of records, except insofar as it pertains to maybe some public institutions. But then the FOIA request should be directed to the school, not to the Big Ten.
So now people have been asking on Twitter, that's going to be their argument. Now, Dan, I have an interesting question. I don't see a way for them to get out of discovery with this. So this lawsuit here with Nebraska players was filed in Nebraska state court. They're seeking, if you read the complaint, they're seeking the same level of discovery. They're seeking the transparency into how the vote was arrived at. So I don't know how the Big Ten is going to avoid giving over discovery in the purpose of this case. I think the Big Ten parents, Nebraska parents, I know we have some people on there that are with those different groups. I think they're going to get the discovery, either through this lawsuit or through, FOIA, if they do it the right way, as Dan's pointing out. Do you think that this lawsuit might also maybe even quicker to get at the discovery that they're looking at?
I don't know if Discovery is going to come quickly enough to save the, the Big Ten, season. We're already in late August. There's a fuse of just a couple of weeks between now and the start of the Big Ten season, and I can't imagine that players, parents, or coaches are going to have any standing to be able to force a private association to play games. That's an affirmative injunctive relief. They may get information to bolster claims down the road and maybe seek some kind of relief eventually. But we're talking about a ticking, time window here. Day by day, it almost is entering the point of mootness unless they get complete relief within the next couple of weeks. And that just seems unlikely when you consider that any kind of injunctive relief that's entered by a lower court will be, or I'm not a Nebraska specialist, but most injunctive orders in federal court and state courts are immediately appealable. So this is just going to go up the line, one more time, and it's going to go into September easily.
Dan, I've called you a lot of things. I've never called you a Nebraska specialist. That is one of the few. So that being said, 7:14. I promised my lovely wife Rachel that I would eat dinner at 7:15. Dan, unless you have anything to wrap up, you can get me out of hot water by ending this on time.
I'm looking at my notes. I think we've covered all the grounds. And, for those law students, out there, I would take a look at the Hairston versus Pac-10 out of the Ninth Circuit. That would pretty much undermine the breach of contract claim if the court follows that Ninth Circuit precedent. And then, tortious interference has basically no legs on an as yet implemented NIL statute. So the two main claims have serious problems.
Listen, you heard it here first from Dan. Dan is undefeated. He's made about 1,000 predictions in his life. He's about 1,000-0. So if Dan says that this case is trouble, it's got a lot of trouble. Thank you to everyone for joining. We'll make this available. If you jumped in late, we'll make this available on YouTube and elsewhere. And that being said, we will see you next week on another episode of Conduct Detrimental. For Dan, Mike, and our newest addition, Karen Sharma, we'll see you then.
Have a good night, everybody.